CPL quiz number 5. Number 1, 300.10. Which of the following are true about requests to charge? And this is literally the paragraph and what it says. They may be made before or after court charges jury. The court must rule promptly on each request, and a failure to rule upon a request is deemed a denial thereof. So the answer is A, 1, 2, 3, and 4. So here when they talk about charge, they're talking about the court's instructions to the jury. So an example of a charge or an instruction that the jury would get, if it was requested only, would be instructions about defendant not testifying at the trial. Okay, so number 2 talks about consecutive counts. So what's the difference between consecutive and concurrent counts? Consecutive counts are best described as counts for which consecutive sentences may be imposed. So consecutive sentences means that you serve one sentence and then you serve another. Concurrent sentences is what usually happens, and that means that you're serving multiple sentences simultaneously. So concurrent counts are concurrent sentences only may be imposed, and consecutive counts are counts for which consecutive sentences may be imposed, but they don't have to be. Who must be present when the jury announces its verdict? And it's court, defendant, defense counsel, and it's any prosecutor. It says a prosecutor. It doesn't have to be the DA that tried the case. 4. If defendant is found guilty of a crime they're not responsible for by reason of infancy, and they're not guilty of any crime that they are criminally responsible for, and they're not awaiting sentence or under sentence for another criminal conviction, the jury's verdict shall be deemed vacated and replaced by a juvenile delinquency fact determination. And then the case would be transferred to family court. Number 5, when must the court deliver a charge to the jury? At the conclusion of summations. 6, a deliberating jury may be discharged by the court without having reached a verdict when 1, the jury has deliberated for an extensive period of time without agreeing upon a verdict with respect to any charges submitted, and the court is satisfied that agreement is unlikely within a reasonable time. True. 2, everyone consents, court, people, and defendant all consent. 3, a mistrial is declared pursuant to 280.10, and that is also true. So that's the 3 times that a deliberating jury may be discharged by the court without having reached a verdict. So the answer there is A, all of them. 7, which are true? 1, a defendant may always waive a jury trial. That is not true. 2, such waiver must be in writing. That is true. 3, the waiver must be signed by defendant in open court in presence of the attorney. And that's true. And the court must give a reason if it's being denied. So 4 is wrong. And defendant may not waive a jury trial for murder in the first degree. So that's why 1 was wrong. So the answer was D, 2 and 3, but not 1 and 4. 8, which are true concerning a non-jury trial of an indictment. Now, 1 says the court must allow the parties to deliver openings. That is true. 2, the court must allow the parties to deliver summations. Also true. Now, this is different than in a lower criminal court trial. This is not true. So make sure you know here we're talking about an indictment. 3, at the conclusion of the case, the court must consider the case and render a verdict. That is true. So the answer is A, all of them. 9, which are true? After a verdict has been rendered, 1, it must be recorded on the minutes and read to the jury. 2, the jurors must be collectively asked whether that is their verdict. And 3, upon application of either party, the jury must be polled and each juror separately asked whether the verdict announced by the foreperson is in all respects their verdict. And that is also true. So they must answer in the affirmative when they're asked if it's their verdict. And then if someone makes an application, would you like the jury polled? They request to have the jury polled. Then the clerk would ask each juror separately, juror number 2, is that your verdict? 3, is that your verdict? Whatever. 10, which are true concerning the non-jury trial of an information in a local criminal court. So compare this to question number 8. The court may allow, okay, I'm just going to tell you the correct answer. So the court must allow one side if it allowed the other side. So if it allows the defendant to deliver a closing or an opening, it must allow the people. But it can tell the people and defendant, no openings, call your witness in a local criminal court. Whereas in an indictment trial, they have to allow the sides to open. And the court must consider the case and render a verdict. Also true. And so that's why we have 1 here is wrong because it says either the people or defendant. Nope. 2 is correct. It says the court may allow defendant to deliver a closing. That's true. 3, the court may allow the people if it allows the defendant. That's false because it's the court must allow the people if it allows defendant to deliver a summation. And 4 was correct. So the answer there was only 2 and 4, but not 1 and 3. So C. 11. In a jury trial of an information conducted in a local criminal court, the jury shall consist of B, 6 jurors and 1 or 2 alternates. You cannot have more than 2 alternates in a local criminal court. 12. The people and defendant may submit requests to charge, and it's all of these. Before court charges, after the court's charge, in writing, orally, or on the record. A, 1, 2, 3, and 4. Number 13, in which if any of the following are true. 1. Consecutive counts are counts upon which consecutive sentence may be imposed. True. 2. Concurrent counts are counts upon which concurrent sentences only may be imposed. That is also true. 3. Every count not submitted to the jury is deemed an acquittal. That's not true. It's deemed dismissal. 4. If the court is authorized to submit a lesser included offense, it must do so if requested by people or a defendant. That is true. So the answer was D, 1, 2, and 4, but not 3. 14. An indicted defendant may at any time waive a jury trial and consent to a trial with no jury in superior court where indictment is pending, except when indictment charges murder first degree. So answer was E, 1 only. You can waive a jury trial for murder second, kidnapping first, and all that other stuff. It's only murder in the first degree. It has to be a jury trial. 15. In the city of New York, the trial of an information which charges a misdemeanor must be a single judge trial if the authorized term of imprisonment is not more than 6 months. Now, of course, case law has slightly changed this thanks to the New York Court of Appeals and their ruling. So the reason that it has to be a jury trial, because the federal government, the U.S. Supreme Court, like the highest court in the country, said that if someone is going to be incarcerated for more than 6 months, they have to be entitled to a jury trial. So that is why in New York City, they went with the bare minimum, and you do not get a jury trial unless the sentence is more than 6 months, which is the highest court decided. This is different in every county except the counties in New York City. So there's 62 counties in the state of New York. Out of those 62, only 5 of them do not give you a jury trial for any misdemeanor. And those are the 5 counties in New York City. But everywhere else, you get a jury trial for any misdemeanor. In a jury trial, the information in a local criminal court, the number of peremptory challenges is 3 plus 1 is the best answer. A, because it's 3 plus you. In local criminal court, you do not get the same number of challenges for the alternates. You get only 1 challenge for every 2 alternates. So that means if there's 1 alternate, you get 1 challenge. If there's 2 alternates, you get 1 challenge, and there can never be more than 2 alternates. So the maximum you'll ever have per side is 4 in a local criminal court. 17. If the court fails to rule on a request to charge, that failure is deemed a denial.